Good afternoon, all. Welcome to the Appellate Division, First Department. My notes say here that you have requested a total of 5 hours of argument. That would put us to 7 o'clock. It's a beautiful day outside. I'm sure none of you want to be here till 7. So what I ask is, since we are a hot bench, that you ask for the time you need to convince us of what you believe are your strong points. You don't need to educate us about your appeal because as a hot bench, we are familiar with the record, the briefs, and the arguments. People versus Hidalgo. (525). Intelli versus New York City Department of Transportation. Submitted. B. Children. Submitted. Chongqing Hong Song versus Kinderhook Industries. I'm sorry? You can do it now. The motion is granted. I assume you have papers, you have a brief filed in this case? Okay, so counsel, how much time do you want? Okay, 5 minutes. So it's 5, 2, 5, and 5. And C limited?
Plaintiff's appellants request 4 and 3, Your Honor. Respondent requests 7, Your Honor.
4, 3, and 7. Zhang versus MasterCard, submitted. Baxter versus LPI? 5, 2, and 5. People versus Wallace. 4, 2, and 4. Wells Fargo.
Respondent, we request, Wells Fargo, we request 6 and 1, Your Honor. The counter-petitioner, respondent appellants request 7, 5, and 2.
7, I'm sorry, you 5 and 2, you got it.
Respondents appellants request 7 and 3, Your Honor.
5 and 2, anybody else?
Respondents.
Just respondent, right?
Sorry?
You're just a respondent?
Yes.
Okay, what are you looking for, sir?
10 minutes.
5 minutes. So 6, 1, 5, 2, 5, 2, and 5. Cleopatra, submitted. Going back to the last case, Wells Fargo, I do want to note for the record that Judge Michael is recused from that case. Seaman versus HQ Capital. 7, 3, and 7. Bonifacio versus Sewell. It looks like you don't have an adversary. Do you wish to submit, sir? Or do you wish argument? You wish argument? Okay, I'm going to give you 3 minutes. Malgero versus City of New York. Just the appellant. Is there somebody else? Oh, sorry. No. My apologies. So I'm sorry, going back to the appellant, you want 4 and 2. Okay, 4 and 2 and 3. And finally, Kwan versus Bryant Park. Submitted. First case up is People versus Hidalgo. Okay, when they come up, I'll deal with them. Okay. Do you want to, yeah. Should I say it? Let's see what, yeah. What happened? They didn't get up? They didn't stand up. They didn't stand up.
No, they did.
Oh, they did?
Yeah, they did. They're on the side.
Okay, okay, we'll deal with that then. Okay. You make comments, counsel.
Good afternoon, Your Honors. Catherine Sullivan of the Legal Aid Society for Alex Hidalgo. Mr. Hidalgo's sentence should be reduced in the interest of justice to the statutory minimum of 3 to 6 years. Mr. Hidalgo was given 7.5 to 15 years, the statutory maximum. Incarceration is a problematic response to people.
Counsel, in terms of the waiver of right to appeal, if we were to agree with the court and the way they executed the waiver of right to appeal, what authority do we have to now consider your arguments? Or should we consider, how do we consider your arguments?
Yes, Your Honor, I think you should consider our arguments. The court has a heightened duty to demonstrate that Mr. Hidalgo knowingly, intelligently, and voluntarily waived his rights on the face of the record. And on the record, Mr. Hidalgo explicitly said he was taking medication that would cause him to be confused. His attorney also said that he may have difficult understanding.
So that's an argument for that the waiver was ineffective. I think the question that my colleague asked, or at least what I want to know, is if we disagree with you on that point, if we think that the waiver was sufficient, can we consider your request for reduction?
No, I believe you cannot, Your Honor, because there is a waiver in effect. Okay. Incarceration is a problematic response to people in the mental health crisis. The social science and even D.A. Bragg agrees with this. I'm not sure if you have read D.A. Bragg's most recent New York Times essay last month, but in it, he discusses how incarceration is not a solution for people with serious mental illness. And Mr. Hidalgo is such a person who needs treatment and support, not lengthy incarceration.
Well, there's no question that he has serious issues, including 2 traumatic brain injuries, correct?
Yes, Your Honor.
Okay, but I take it that the lower court in fashioning, and the parties in fashioning this plea agreement took that into consideration.
Yes, Your Honor, but you, as you all know, have a court that have plenary power to supplement your own discretion in this, and this is what we're asking the court. 3 to 6 years is still a very long time to Mr. Hidalgo. He is someone who has a limited lower culpability. As you discussed, he has a TBI. He has definitely a lower cognitive functioning, and this will also meet the requirements of the tenets of punishment, but will allow him with a lesser time to enter the community and to be a safe and active member of the community. And as you know, usually clients with serious mental illness receive inadequate treatment and greater punishment in prison, which can only then harm his reentry process. He does not have a life sentence. He will be released. And so our hope is that with the minimum sentence, our client will be able to then get the support he needs, which is treatment and not incarceration, to move forward. As he is an OMH level 1, which means that there are certain guidelines that have to be met on his reentry. If he's given parole, he has a parole officer with a 25-to-1 caseload that have to connect him with an ACT and wraparound teams. The IRCs give him help in finding housing, and he does have the support of his father and his sister. And to the appeal waiver, if you are to agree with my argument, the court had a heightened duty to demonstrate, as I said, that he was knowingly, also that they did not provide an accurate description of the rights that he was maintaining and waiving. The trial court never said he had the right to counsel on appeal. They said you maintain some rights, you can still appeal. That was the extent of their description. And People v. Bradshaw requires that the trial court provide enough assurance that Mr. Hidalgo understood the shorthand for the rights he maintained. Also, the written waiver cannot salvage this inadequate oral colloquy. Most importantly, Mr. Hidalgo is functionally illiterate, so is not able to read the written waiver.
Did anyone go over the written waiver with him verbally?
It's honestly confusing on the record. So the defense attorney says that the Spanish interpreter went over the record with the written waiver with him, and then he signed it. And then later on the record, the trial attorney asks, "Oh, he hasn't signed this. Do you want me to sign it for him?" So it's unclear, but on the record, it was never read to him. And again, the oral...
You're saying that the requirement is that it would have been needed to be read to him on the record? Or is your argument that the question was never asked, that did he understand the waiver and did he go over it with his attorney?
Correct. I think no, I'm not saying that the written waiver was required to be read to him on the record. I'm saying that it is unclear if the written waiver was ever read to him, that he was not asked that question.
Thank you.
Good afternoon, and may it please the court, Catherine Murata for the people. To begin, defendant validly waived his right to appeal for closing review of his excessive sentence claim. In any event,
What about issues raised with respect to his mental illness, the intellectual disabilities, his really maybe ability to understand what was being said to him?
well, I do believe on the record it is stated that the Spanish translator did read the waiver to defendant, and defendant authorized his counsel to sign for him.
But that's no indication as to whether he understood it,
Although
right,
he-
in light of his disabilities.
Right, correct. But throughout the proceeding, he never expressed any confusion about the written waiver. The judge gave him ample opportunity to voice any misunderstanding about the waiver. In addition, as to the oral colloquy, the judge frequently asked defendant if he understood the proceedings.
How do you respond to the argument made by your adversary that the court here, there should have been a heightened duty given the intellectual disability, mental issues that he was dealing with? Are there cases that support that position?
I think there are cases that support if a defendant has intellectual disabilities, there should be a heightened awareness. But I think the court here did satisfy that. Justice Neubauer frequently checked in with defendant, asked him if he understood the proceedings, if he understood the colloquy, to tell the judge if he did not understand anything. Counsel nor defendant expressed any concerns or misunderstanding. Defendant stated that he discussed the waiver with counsel and he had no questions. So I think even though there was a heightened standard, it was satisfied here.
Counsel, didn't the court also simplify the language so that the defendant could understand what was being asked of him?
That's true. The language was easy to understand. Basically, the judge said his appellate rights are separate and distinct from his trial rights, and specifically, he is waiving his right to appeal the length of his sentence, which is what he is bringing here. So I believe it was a straightforward, concise description of the appellate rights, and defendant expressed no concerns about.
Did the court say anything about the ability to challenge an excessive sentence?
Yes, he said specifically that he's waiving his right to appeal whether his sentence is excessive, which is the claim that he's bringing now. Just to note, in any event, his sentence is fair and appropriate, as you noted, Judge Rodriguez, that the sentencing court was well aware of all his struggles with mental illness, substance abuse, and his childhood struggles, and took them into account when crafting his sentence of 7.5 to 15 years. And just to note, he pled guilty to a single non-felony count of arson in the 3rd degree. He was originally charged with arson in the 2nd degree, which is a Class D violent felony. If he was convicted of that count at trial, the court would have been required to sentence defendant as a mandatory persistent violent felony offender, which would have greatly increased his sentencing exposure to a minimum of 20 years to life. So he did receive a significant benefit by being able to plead guilty to arson in the 3rd degree. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
I would just like to reiterate that that both Mr. Hidalgo and his trial attorney said that there could be problems with understanding, and that as we raised...
Counsel, if I may, did the defendant, did he express any confusion with respect to the court's colloquy?
I think to answer that, Your Honor, I would say that as you guys found in People v. Patillo, that when...
Well, actually, it's usually a yes or no, or you can point me to, the page in the record where the defendant says, I don't understand, poses another question. Is that the case here?
No, Your Honor, he did not. I will say that people with intellectual disability are known to be more susceptible, to be more gullible, as we raised in the brief, this yay saying idea.
I'd like to follow up, if I may. Did defense counsel raise with the court any difficulty that his client had in understanding the colloquy? Maybe you can point me to a page in the record where defense counsel, brought it to the court's attention that the defendant did not understand. I have it here too. You can direct me to that.
Yes, Your Honor. I'm just looking for it right now. Yes, on page 8 of the plea, she says there are other reasons he may have difficult time with that, that being the colloquy.
I see. But nothing particular with respect to what the court said. He didn't, can you repeat that? He didn't understand anything?
No, Your Honor.
Now, one more, and then I'm going to pass on this. Does the defendant have any prior experience with the criminal justice system, any prior convictions, any prior pleas here?
Yes, Your Honor. He has 2 prior convictions. I will say both of those required him to be Article 730 multiple times, which then again shows like his deep mental illness. If nothing else, I will rest on my papers.
Thank you.
Thank you.
Chong Quing Hong Song versus Kinderhook Industries. You may begin.
Thank you. Good afternoon, and may it please the court, Ben Fleming for appellants. In dismissing the fraud claims here for lack of scienter, the trial court made 2 overlapping errors. The court ignored the well-pleaded evidence of the suspicious nature of the transactions at issue here, and the court openly and avowedly drew factual inferences against the plaintiffs at the pleading stage, as the court can see from the oral argument transcript.
So in this case, the defendants made substantial payments, correct?
Yes, on a multi-million-dollar debt, yes.
And, well, how much did they pay?
There's something like $60 million outstanding overall.
How much did they pay, sir? Millions?
Yes, millions.
Is it 40 million?
It depends what time frame you're talking about, Your Honor. After the transaction at issue, the 2021 leverage buyout, yes.
But in any event, substantial payments. In light of those substantial payments, how do you make out this claim of this fraudulent scheme to deceive?
So there's a couple ways you could look at that, Justice Singh. One is through the lens of scienter, and I think that's how the trial court looked at it. The trial court found that those partial payments, or perhaps the offers of payment plans by Kinderhook in summer 2022, negated any other inferences of scienter that could be drawn from the record. And our view is that was the error. There are inferences of scienter that can be drawn from the fact that, as alleged, the initial transaction in which Kinderhook acquired control of PPG from Godfrey in 2021 rendered PPG insolvent. Godfrey took out nearly $70 million in cash. Kinderhook took multi-million-dollar transaction fee. And the allegation, and again, this is in the complaint, paragraph 25, pages 47 and 48 of the record, this rendered PPG a husk, unable to pay. And our point is that it is a rational inference to think that at that moment in time, there was never any intent of Kinderhook to step in and cover the shortfall at any time thereafter. We think that's at least a rational inference that could be drawn from the facts, and because of that, we don't think the trial court was in the business of weighing competing factual inferences at the pleading stage. I grant that the arguments about partial payment might create an argument that they could raise later.
But more than an argument. I mean, isn't there case law in this department that we take into consideration substantial payments or payments of this kind in considering whether or not there's a fraud on in essence, a breach of contract action?
I don't think so, Your Honor. There are 2 cases that are focused on most in the briefing, are Green, a second department case that I think is fairly conclusory on this point, and then FNF Touring, which is a case that, like Green, involves a pure counterparty situation. In other words, there are 2 contractual counterparties. The claim is that a counterparty is just doing partially what it owes under the contract. That's not this fact pattern. Kinderhook is not a party to these contracts. It is a third party. It comes in after most of the contract has been entered into. We grant that. And it functions as a guarantor. That's a variable that's not
Functions as a guarantor?
Yes, the promises are essentially that Kinderhook will act as a guarantor on the outstanding debts, and that is
But
not the
counsel,
fact
I
pattern.
don't know why that doesn't work against you, considering the fact that they then went on to make these substantial payments. So it wasn't that they had the intent to fraud or no intent to ever pay, it's that we tried to pay it and we just couldn't.
Your Honor, that is a perfectly good argument to plead and prove. I don't think it negates any inference of scienter at the pleading stage. And again, partial performance is completely consistent with fraud if the idea is that this is going to string things along and drag things out. And I think that's entirely rational here. You can't buy a company with debt on day one, go bankrupt on day two. That's the sort of thing that you get the FBI called on you if you do that. But dragging it out has benefits.
But is that what occurred here?
Well, within six...
That's a little bit of hyperbole, right?
Well, it's not what happened. The company went into bankruptcy within 16 months, and it's since reemerged.
After paying substantial amounts on debts that were owed, correct?
Yes, and look, I am open to the idea that they're going to make an argument that it would have been economically irrational to do what we say happened here, which is, in other words, hollow out the corporation. I think the IKB International case addresses that type of argument at the pleading stage. There, the RMBS issuers said it would have been completely irrational for us to issue these loans, these securitized loans with bad debt in them, that we would have lost money in the deal. This court said that's a perfectly good argument that you can raise at the pleading stage or after the pleading stage. It does not knock you out on a 3016B motion. And I think that's the same thing here. These are factual disputes. The record is full of these, and I think that discovery is needed on these points. Briefly, one final point about the judicial notice motion that Kinderhook has filed. Just want to make 2 points briefly about those. One is that they're asking the court to take judicial notice of an adversary complaint filed in the PPG bankruptcy proceeding. This is an adversary complaint that was filed months after the dismissal at issue here by a third party, the litigation dismissal at issue here by a third party, the litigation trustee for the defunct PPG. It's not us.
Bottom line, you say we should deny that motion, correct?
You can deny it or grant it and ignore it, but I think it comes out to the same thing. It's not us. It's like saying...
Thank you.
Yep.
Good afternoon, Your Honors. Lamina Bowen of Kirkland & Ellis on behalf of the Kinderhook respondents. At this time, I respectfully move for the admission pro hoc vice Bill Arnault, who will present argument in this matter.
Granted.
Thank you.
Good afternoon, Your Honors. Bill Arnault on behalf of the Kinderhook respondents. May it please the court.
Can you respond to the argument that, in essence, if we were to affirm that we would be maybe doing some violence to a 3211 motion? Obviously, this is not summary judgment. Your arguments on summary judgment with respect to substantial payments would be very powerful.
Yeah.
But at this stage, why shouldn't they get discovery with respect to their allegation that you, in essence, stripped over maybe many months the company, and this is all part of a fraudulent scheme?
Well, so I think there's a few points there in response, Your Honor. First of all, they've had 3 opportunities now to file and draft a complaint, and there have been 3 motions to dismiss where they have yet to allege any facts sufficient to state a fraudulent misrepresentation claim. Moreover, when we filed our motion to dismiss in front of the trial court here, they waited 100 days, and they could have amended again. They chose not to. So that was a strategic decision on their part to see how it would play out in front of the trial court, and they lost that gamble. And putting to the side the ability to seek discovery, here they've affirmatively pled themselves out of court based on their own allegations, which prove that there was no present intent to perform as a result of the partial payments and the fact that payment proposals were made. Moreover, their own allegations show that there could not have been justifiable reliance because their entire theory is that they were kept in the dark. But of course, they knew that they were not being paid. And as a result, there could not have been justifiable reliance, even if there were fraudulent misrepresentations here, which we submit there were not. Because if you actually look at what was alleged, we hear this theory now that prior to the acquisition, Kinderhook said that it would pay the debt in full. But if you actually look at the complaint, the only conversation prior to the acquisition was a brief meeting, as they allege, where Kinderhook said, we are acquiring the company and we hope to continue to do business with you. That's it. That's the basis for their fraudulent misrepresentation claim prior to the acquisition. After that, it's 7-8 months until Kinderhook and the appellants actually talk again. And at that point in time, it's the appellants who reach out and request a meeting with Kinderhook to inform Kinderhook of the amount of the debt and how long it's been outstanding. And so there are these, I mean, it's quite literally every element of a fraudulent misrepresentation claim is not met here. And so to your question, Your Honor, it would do a lot of harm. We've been doing this for a year and a half at great cost, having to respond to frivolous complaint after frivolous complaint. And to continue to do this when there are no set of facts, as we have seen now 3 times, that they could ever state to actually allege to state a claim, it would actually do great harm to us. They've had the chance to actually state a fraudulent misrepresentation claim, and they have not been able to. And I'll make the point, Your Honor, on this, the payment plan, going back to this idea that they need to show a present intent not to perform. Kinderhook tried to perform, but those partial payment plans were rejected by appellants. And how do we know that appellants knew that they were not going to be paid in full? Because they came back with a counter proposal asking for payment less than full. So this idea that there was this stripping of assets at the outset of the LBO is in fact contrary to their own allegations, and it's come back to a prior question, where they were paid nearly $50 million over the course of the time period captured in the complaint, as they themselves have alleged. And so, again, Your Honors, we don't think that they have pled scienter. We don't think they have pled justifiable reliance. We don't even think they've pled any actionable misrepresentations, because under the law, a mere promise to make a payment in the future is not actionable in fraud. And where partial performance, even if shoddy, occurs, the law is clear that that cannot maintain a fraud claim either. And so with that, Your Honor, we would respectfully request that the court affirm the trial court's decision on any number of grounds that are very clear here. Thank you.
Thank you.
Your Honors, may it please the court. Paul Girding on behalf of Mr. Godfrey. I apologize for sitting on the wrong side here. We were short on seats. So I just go point to what the court said, that this was just a textbook case of an example of a situation where there's just insufficient allegations of fraud. And the reasonable reliance that Mr. Arnold talked about, I'd like to talk about that just a little bit further. During the case, there was the original LBO offer of, we're creating a new company, we're going to create this PPG company, and here's Kinderhook, there are new partners, there are new people, they're the new owners of the company. There's no fraud there. There was no misrepresentation by Mr. Godfrey. It was just a statement of fact. They're a very wealthy entity. They're coming in. They're going to assist with the takeover. They're going to help run things in the long run. There was a follow-up conversation, and there was a representation allegedly with Kinderhook that came in June of the following year, and that was when, in negotiations between the plaintiffs and Kinderhook, not Mr. Godfrey, because that time Mr. Godfrey had already stepped down from the position of CEO. He was not involved in it, so he can't be held liable for any representations made during that time. What the court focused on, and what's most important, is during the time from October of 2021 to June of 2022, it was really the plaintiffs who were well engaged in negotiations with Mr. Godfrey, CEO of PPG, the debtor, and with Kinderhook, the owners of the debtor. And they were constantly negotiating, as the court pointed out, to get paid. So she called it a carrot and stick. Are we going to get paid? Are we going to get paid? Well, we're not going to give you any more product till we get paid. So Kinderhook and Godfrey would make certain that PPG paid what was due, and that's exactly what occurred. In January of 2022, and there were only 3 representations that Mr. Godfrey is allegedly liable for, the original LBO representations, the January representations that $7 million was forthcoming, and the follow-up of we're going to make more payments that are going to come through Kinderhook in the future. In January of 2022, Mr. Godfrey represented that he was told that Kinderhook would come in with $7 million. The plaintiffs are saying, well, that's a misrepresentation. You're baiting us to give you more product. When in reality, Chris Hunter, as the record reflects, the treasurer for the company, was saying to plaintiffs Are we good? Is this enough for us to get more product? So what was really happening here where plaintiffs were asking for more, asking for more money, and the defendants were giving what they could. Here's the money that we could give. Again, 40 million, ultimately 50 million. Plaintiffs called that they're just throwing us a bone, but there's a lot of meat on that bone.
So it's your position, I think, that the inference to be drawn here is that you intended to pay, but were unable to ultimately meet those obligations. Is that correct?
Absolutely, Your Honor. There has to be a present intent to defraud. There has to be a present intent to lie, and that wasn't the case. This was just the intent of a company to try to get more product and try to stay on its feet. It was no secret to the plaintiffs that PPG was in trouble. They said so, and they were negotiating, we're doing the best we can, here's more money, here's more money. And again, $50 million on an original $60 million obligation is a significant amount of money. It's the whole porterhouse, it's not just a bone. So eventually, the plaintiffs decided, we're gonna give them some more product and see if we can get some more cash. But there's no intent to defraud there. This is just a flat out negotiation to see what we can get to try to resolve the issues between them. With regards to the, I have to agree with Mr. Arnault relative to the pleading issue and the amending of the complaint. Again, I'm sorry for being too cute, but they keep wanting a bite out of the apple or a second bite of the apple. Here they've had a bushel of apples. They keep going to various courts. They're seeking more and more attempts to try to get beyond the bankruptcy pleading and beyond what this is really about, which is just a very simple breach of contract matter and trying to make it a tort case. And frankly, Your Honor, that's just not the case here. Thank you.
Thank you, counsel.
Just a few points, Your Honor. First, on the 3 motions to dismiss, I don't think any of that is correct. This is the first motion to dismiss in this case. This was the first complaint in this case. What's being referenced by the respondents are 2 pre-motion letters filed in a Southern District action that was eventually voluntarily dismissed for reasons that have nothing to do with this case at all. There was originally an action brought against PPG. The automatic bankruptcy stay required amendment and getting them out of the complaint. Then there was a subject matter jurisdiction challenge. This is all cited in the briefs. This is all a red herring.
You want to address the issue with respect to the dismissal with prejudice?
Yes. Again, we read the trial court's opinion, and the court can take a look at the transcript just like we can. We read it as hinging on scienter and perhaps this argument that there's a duplicative nature of the breach of contract claim. Those are the only issues that the trial court flagged. If the court agrees with the trial court that the partial payments are dispositive, then the amendment would be futile. The trial court did not make that finding, though, and for the reasons I covered at the topside
But
argument.
if that's the case, why didn't you make a motion to amend? You had an opportunity as of right, and you also had an opportunity to make a request. So why didn't you make that motion?
I'm sorry, Your Honor, I don't agree we had an opportunity to make a request. The trial court dismissed the complaint with prejudice at the close of a 20-minute oral
In
argument.
response to the motion to dismiss, you could have cross-moved.
Well, again, this goes back to we disagree that the pleading doesn't sufficiently allege scienter. But I do want to say on this justifiable reliance point, the court knows as well as we do, that's not an issue that's usually decided in the pleadings, and for good reason. It's extremely context-specific. It requires facts to be developed, and none of that has been done here. We would suggest that reliance is a particularly bad issue to be decided on this record. And honestly, the same goes for the breach of contract issue. This is not like a case where there's just a contractual relationship. There's a third party here, Kinderhook, making additional representations. It's really outside of the mine run of duplicative cases. And for that reason, we ask the court to reverse, send it back so there can be discovery.
Thank you all. C Limited.
Good afternoon, Your Honors. Joseph Russell for the plaintiffs' appellants. We're here to request the court to reverse the trial court's dismissal decision. The court made at least 2 errors that require reversal here. The first is that item 303B, an SEC regulation, required disclosure of India's national security policy adopted after hostilities arose with China. which resulted in the ban of apps even with perceived ties to China. That was in June 2020. That's the first ground in which the court's decision requires reversal because the court never addressed that issue. The second is item 303A and item 105, which respectively apply to known uncertainties and risks, also require disclosure of the risks and uncertainties arising from the national security policy adopted by India, which resulted in these bans.
But in terms of, with respect to the issue of risk, was the risk of a ban of the app by the Indian regulatory authorities known to defendants, and was it reasonably likely?
Yeah, so, Your Honor, we think that what defendants have raised really are factual issues. We don't think that investors knew about the possibility of a ban, but we do think that the company itself did. The reason being that when India adopted its ban, it was exceedingly broad. It still is, to this day, exceedingly broad. There was never a criteria that was put on the ban that said it was only going to apply to companies that were owned, companies that owned or published apps. It was exceedingly broad because the country was not going to limit itself in constraining the influence and the ability of the Chinese government to gather and exploit information on citizens. The company actually did make one disclosure in its 20F, which was its annual report incorporated into the offering materials. The only disclosure made was if any of our key games, including Free Fire, is banned or temporarily suspended by any government, court, or distribution channels, our business, financial condition, and results of operations may be materially and adversely affected. That's at the record at 224. So, Your Honor, we think the reason why the company had an understanding that this ban may apply was because Tencent actually had its COO on the Sea Limited board. Tencent had outsized ownership of the company, about 23%, which resulted in 44% voting control.
Also, let me just stop you right there
Yes,
on
Your
that
Honor.
particular issue, because in the where they make references between the Taiwanese government and the People's Republic of China, they actually attach monetary amounts to that of 30%. So even if we're going to take your argument at its face, it didn't even reach what the People's Republic of China restriction was. So how does that come into play?
Well, Your Honor, the Taiwanese disclosure is important only for the purposes of item 303B. And the reason being that there was a restriction on foreign direct investment in Taiwan. And the restriction applied to the notion that there are tensions which were described, again, in the 20F, that went to the heart of problems between Taiwan and China that could result in a problem for Sea Limited. Sea Limited, in fact, concluded, after consulting with its lawyers as it described, that there was no risk at all, and yet there was a disclosure of that issue. Here, what we're saying is Free Fire was an exceedingly important app for this company. Free Fire became the most popular app in India at some point. It was clear that there was a target on their back because of the connection to Taiwan, rather to Tencent. And I just want to point out, our allegations have always been that the ban applied to apps even with perceived ties to China. And we say that.
What do you base that on?
So we allege that basically on the breadth of the policy, and I could take you to that, Your Honor. It's a great question. The defendants put this into the record. It's at...
Do you have an example of the Indian government banning an app because it was perceived that there was some Chinese involvement, but not ownership?
So it's a tricky question. And what I would say, Your Honor, is that two things to that. One is that we alleged that Crafton had its own app banned, but of course Tencent was a publisher at the time.
Which is a difference, right?
Which, it's a difference, Your Honor, but we don't think it's a substantive difference. And this is why, because if you read the policy itself, let's assume that we put aside any factual issues for now. If we look at the policy, it's at 667 in the record. It doesn't actually identify China at all. China is not mentioned. The reason for that is because companies that operated in India understood that what India was doing was it was tightening restrictions on apps that could gather information about Indian citizens for the exploitation purposes of the Chinese government. Certainly where Tencent, which had its own apps banned several times, was a significant owner of this company, had significant influence, that would certainly put in the crosshairs this app. And as we see, things kind of progressed as they went. The defendants would like to say that because there was a lull in bans, so to speak, that meant that they had reassurances that there would be no ban. That, in fact, is not true. India never lifted the ban at all. There was no cessation of the enforcement activity. And in fact, in January 2021, India then officially permanently banned additional apps. But I would just urge the court to read that press release because we all agree, respondents and appellants, that this policy was geared toward China. We agree, yet it makes no mention of China. So they would accept that allegation, but they don't accept the allegation that applied to even apps with perceived ties. And there's a problem with that.
Counsel, you're on the red light. You want to finish up the thought and then?
Yes, absolutely, Your Honor. The only point I wanted to make was that there are factual issues here that would require the court to construe all of the inferences in the respondent's favor. Those inferences arise from the allegations that we have in the complaint based on the breadth of the policy. It's in the record at 148, 152, 154, basically paragraphs 77, 92, 96, 99, 110B, and 111, where we say the policy was extremely broad. For the respondents to come in and now turn the burden on us to identify companies that were not owned or published by Chinese companies, which, by the way, we don't know what that means. It's another factual issue. Was it incorporated in China? Is it based in China? These are exceedingly, and I just want to wrap it up, but these are exceedingly opaque corporate hierarchies, structures. It's very hard to figure out. And I doubt that the Indian government wanted to restrict itself in that manner. Thank you, Your Honors.
Good afternoon, Your Honors. Adam Hackey from A&O Sherman for the respondents. The trial court should be affirmed for three basic reasons. First of all, the disclosures in fact warned of the very category of risk that happened here.
But this is what I find sort of interesting. You have this big discussion about Taiwan. We know historically, and I think your adversary concedes that it's not with respect to the investing public, but really the company, of this antagonistic relationship between a superpower and a country that wants to be a superpower, recent border skirmishes in the Himalayas, and then a series of bans. You talk about Taiwan, but you say nothing about India. Isn't that in itself maybe or arguably misleading, giving plaintiff every favorable inference that they're entitled to under securities law?
No, Your Honor. I'm glad you asked. So the regulation, the Taiwanese regulation, was a very specific regulation that spoke to ownership, the ownership chain of the company doing business in Taiwan, which, and as was stated by one of the justices, had a percentage threshold. It was very specific. It was an understandable document that had been on the books for a long time, a very rational thing to disclose, to say, look, we do have a Chinese investor, a minority investor. This regulation in Taiwan speaks to ownership of companies that do business in Taiwan, and specifically Chinese companies. It's a very tangible thing to disclose.
But Tencent's involved. Tencent is involved in the Korean corporation. It's involved in go ahead.
Precisely, Your Honor. Because and that's the point. So as was stated, Sea Limited is one of the most popular mobile games in India. The bans start happening in June of 2020. By the end of 2020, 250 apps have been banned. Okay? Sea Limited, fast forward to when the offering happens, which is the only time that matters, September 2021, is not banned. Sea Limited is not hiding. It's not hiding the fact that Tencent has an interest in it. All of that is public. India is well aware of Tencent, and it's not banned. What is the only inference that Sea Limited could draw at that point, which is that this is not considered to be enough to trigger a ban? And then Sea Limited got specific comfort by what happened with Crafton. This is not us asking the court to make a fact finding. They pleaded this. They have multiple paragraphs in the complaint on exactly what happened with Crafton. What happened with Crafton? In Crafton, Tencent was a minority investor, had a board seat, but it was the publisher of the game, and that was a game called PUBG.
So let's go back to the policy. Does the policy suggest that, well, we look to the publishers of the game? India had a very opaque policy, correct?
It was so opaque it didn't even mention China. So the point is, all you had to go on at that point, and this is exactly what the securities laws say you should do, is what has happened. And what had happened is, C wasn't banned, first of all, even though this thing was on the books for over a year. Second of all, PUBG gets banned. And then, lo and behold, it changes the structure, keeps Tencent as an investor,
Counsel,
changes the
apps-
publisher, and then it's unbanned.
The apps were banned on a rolling basis, right? It wasn't like they were all banned on one day and then
Well,
it
the
just
ban
stopped.
stopped in late 2020 and didn't start up again until long after the offering happened in September 2021. So there was not just a lull, there was a very long period when nothing had happened. And if you're sitting in the shoes of C Limited, you say, I haven't been banned, even though I'm the most visible mobile game in India. A company that changed itself to look just like us by publishing itself and leaving Tencent only as a minority investor comes off the banned list.
Well, why not disclose that?
Well, you can
That
always,
point,
Your
why
Honor,
not disclose
Your Honor,
it?
that's the problem with this case. You can always look at an event that happens 6 months or a year later and say, well, why didn't you disclose
No,
it?
I don't mean from hindsight.
You,
I
you
don't mean
can't
from
disclose.
hindsight.
You can't disclose everything, and honestly,
But I think you're required to disclose things that are reasonably likely to result in a certain way. And the point of the matter is we are at a 32-11 motion. Maybe summary judgment, you have a great argument, but this is where we are now.
3 very quick points on that, Your Honor. There was no reason based upon the record to date, again, to expect that there was a reasonable possibility they were going to be banned. They were out there all this time. They weren't banned. Somebody restructured to look like them. They weren't banned. But then you add the fact that everything in this case that's alleged is public. This is an unusual securities case. There's not one allegation that there was a hidden piece of information within the company. We've cited multiple cases that say a non-disclosure of information that is public is per se immaterial. They can't point to one private fact the company knew that nobody else did. Nothing. The whole case is built.
Wasn't there something in the agreement that indicated that they shouldn't look to anything in the public for information and only look to the agreement?
There is in disclosure documents, there's a general provision that says you should rely on what's here. It is not an instruction not to close your eyes or bury your head like an ostrich and not pay attention to anything else that's out there. And that
Isn't that sort of relying on the disclosure, giving all of the necessary information by placing that within the document?
one could interpret it that way, but case after case has said if all the information the plaintiff is relying was available to the investor, you don't have a claim. It's
Well, that's sort of an interesting question, because then this is maybe looking at hindsight, but once there was a ban, there was a precipitous drop in the stock. So it suggests, as argued in the briefs, that the investing public did not understand what India was doing. So that's why the focus of plaintiff is on what the company was doing.
Can I answer that?
Absolutely.
This was not an IPO. This is really important. This company had been public for a long time. It had a market cap of like $100 billion plus. It had armies of analysts following it, poring over all the public information that was out there about this company. Nobody thought, maybe somebody chatted on a website, nobody published a report saying, oh, these guys are at risk of a ban. The whole market was shocked. C Limited, investors, the analysts, the Singaporean government. That's the reason why it wasn't disclosed.
See, but the problem is that's drawing the inference in your favor. Shouldn't the inference be drawn in their favor under securities law, right?
No, I don't understand that, Your Honor, because again, the fact that the market was surprised doesn't prove that the company knew something they didn't. It just proves that they were surprised. There's no inference there. And I know it.
Aren't you asking for there to be an inference based on the fact that this was a surprise?
That's not my argument. I'm responding to the question. All I'm asking is that we not worry about how they spin it or we spin it, and just look at what the facts were at the time of the offering. That's all that matters under the securities laws. And there's no dispute as to what they are.
Thank you, counsel.
Just very briefly, Your Honors, I just wanted to address the point that was raised concerning what the offering documents actually say about whether investors should rely on it. There is something in the record. It's in the amended complaint. It's at R135. It's paragraph 41. You should rely only on the information that we incorporate by reference or provide in this prospectus. We have not authorized anyone to provide you with different information. We have
But
cases.
that doesn't say anything about public information, right?
Well, Your Honor,
the law is that public information is part of the total mix of information. So you can't, as a reasonable investor, close your eyes. Maybe it says, with respect to the company, you rely on what we say, but doesn't say don't do your own due diligence.
Well, frankly, Your Honor, there hasn't been any indication that investors had an obligation to go search out a policy in India that applied distinctly to Chinese-related companies or Chinese interests. That seems to be something beyond the pale. And if you look at the case law, it's usually a situation where the Wall Street Journal published something 26 days in a row about JP Morgan. Of course, an investor is presumed to know, but we've addressed some of the cases that relate to this.
There are a
in the
lot of old
reply.
cases that maybe support that position, but we live in the information age today. I'm not sure that that argument holds much water.
It's hard to say, Your Honor. It seems that the policy here was something that C Limited and Tencent could construe properly. I'm not sure investors could have reviewed the Indian policy and concluded how it might apply, Your Honor. So that would be my only point on that. And I did want to just close with the notion that
Were the banning of apps regularly in the public, was that known?
Your Honor, we would suggest that it wasn't known here with the degree of intensity that would have to be. That seems to be what's called a truth on the market defense, which is a defense that the respondents can prove at some point with evidence, but can they do it at the 3211 stage? We would suggest that they can't, Your Honor, and I would close on that.
Thank you. Thank you both.
Thank you, Your Honor.
Very interesting case. Thank you, counsel. Baxter. You may proceed, counsel.
May it please the court, Bryn Goodman from Fox Rothschild for defendants, appellants, LPI and Socotec, which I will refer to as the company. We are here today because respondent Baxter has accused the company of breach of contract. The only contract involved in this case provides the company with the unilateral right to modify Baxter's rate of pay. So by
So you're not disputing that there's a contract here? You agree that there's an executed contract here?
The executed contract is the March 2015 letter. Under the March 2015 letter, it provides that the company has the right to unilaterally change Baxter's rate of pay. It's on page 38 of the record. And by changing Baxter's rate of pay, the company did not breach the contract. The company performed under the contract. If we take every word in the complaint as true, the March 2015 letter is the agreement, and it is an at-will employment agreement that gives the right to the company to change Baxter's rate of pay.
But doesn't the contract also say that that it's based on plaintiff's performance and defendant's other compensation and policies? I mean, can we decide that as a matter of law at this juncture?
Yes, as a matter of law, under paragraph 2 of the contract, which you're referring to, the compensation provision provides this is the salary, which may be in effect from time to time, as may be in effect from time to time. You can see the language. And then it says that the company will review it annually based on performance, job duties, and the company's compensation policies. And if you read that in connection with paragraph 5, which is the termination provision, and I urge the court to look at page 40 of the record, paragraph 5B, which provides that Baxter has the right to terminate his employment immediately for good reason if the company materially reduces his salary. So under the contract, the company can reduce his salary and he can quit, as is his right as an at-will employee, which he pleads, or if they...
So in other words, you don't have to consider his performance.
To reduce his salary?
Right.
It can be reduced for any reason. It will be reviewed annually based on his performance and job duties.
So it's an illusory provision with respect to reviewing performance?
No, that provision provides that we'll take a look at it annually. Doesn't necessarily mean that we have to change his compensation.
Fair enough, but this is again a 3211 motion, not summary judgment.
Right, but this is very similar to the Arbini case that this court decided, which provided that where a contract has a compensation provision that gives the company the right to change the employee's rate of pay, it can be decided as a matter of law. And an allegation that the company changed the rate of pay and the employee was unhappy with it is not a breach of contract claim. This is an at-will employee. He pleads he's at will, and he is a current employee and was at all relevant times at will. And under New York law, an at-will employment relationship allows for the company to unilaterally make changes to the terms and conditions of the employment, and the employee's right is to quit. That's their remedy, is to quit. It's not a breach of contract claim. There may be other claims that were dismissed at the lower court, the New York labor law claims, for other reasons, but a breach of contract claim does not exist when it's an at-will employment agreement. And Baxter doesn't allege that that agreement, the March 2015 agreement, was modified in any way. So that right to change the rate of pay persisted throughout the employment to date. The company has the right to change the rate of pay regardless of the allegations in the complaint. And if your honors take anything away from this argument, it's that there's one agreement pled, the March 2015 agreement. The provisions in paragraph 2 and 5 give the company the right to change Baxter's rate of pay, and this doesn't state a claim for breach of contract on its face. There's a allegation that an oral agreement was made for a $75 an hour rate of pay. That still doesn't modify the underlying contract, right? The company could turn around and later change that rate of pay, and therefore changing his rate of pay cannot state a claim for breach of contract as a matter of law. We can also look at Kushner versus Carter Ledner that this court decided, as well as the Court of Appeals case, Hanlon versus McFadden, Jennings versus Huntington Crescent Club, Minovici versus Belkin. There are numerous cases that set forth the at-will employment doctrine, which is what we have here. He pleads he's at will. The contract reflects an at-will employment relationship. So on its face, the complaint doesn't state a claim for breach of contract. Are there any further questions?
Thank you, counsel. You may proceed.
Good afternoon, Your Honors. Kevin Lalonic from Gross Schumann on behalf of the...
So how do you respond to that?
I respond by referencing record page 38 and 40 as appellant did. This agreement does not provide for the unilateral discretion by the defendant.
In other words, are you disputing whether it's an at-will, whether it's an at-will employment relationship or
It
not?
is an at-will employment relationship, but the contract does not provide the employer, the appellant here, the unilateral right to modify the employee's compensation. Section 2 provides your base salary will be reviewed. There's no language where it's saying you have the sole discretion to change the compensation. Paragraph 5B, referenced by appellant's counsel, provides that good reason exists if there's a material reduction in the employee's base salary without your prior written consent, meaning the employee had to agree to the written consent, otherwise it was a breach of contract. Contrast the language in this employment agreement, records page 38 and 40, to the language in the Arbini case, 71 AD 3D 177, which provides that such salary shall be reviewed by management from time to time, and any adjustment to such salary shall be in the sole discretion of management. Those words do not appear anywhere in the employment contract at issue in this case. With respect to modification, we pled that the agreement, that the compensation term of the 2015 agreement was modified in the complaint, in the amended complaint, and in plaintiff's affidavit submitted in opposition to this 3211 motion. Those are pages 52, 73, and 74 of the record. Additionally, we have a supporting document, an LCA application for authorization to work in the United States on behalf of plaintiff, who is an Australian citizen, signed by the CEO of the defendant, and an affidavit saying, of the plaintiff saying, this relates to my employment. It reflects the pay term, $75 an hour, as opposed to $150,000 per year in the complaint. Now, I anticipate that my opponent, that defendant, will argue in rebuttal here that modification can't take effect here because it's only signed by one party. Well, the law in the state of New York is if it's only signed by one party and the agreement requires a two-party signature, the court has to look at all of the evidence and decide whether the amendment is authentic or the parties adopted the amendment. Here, respectfully, we submit that the parties adopted the amendment. At least there's, at minimum, an inference of adoption. We alleged at paragraph 14, record page 34, the rate pay modification. At paragraph 17, page 34, a complaint for underpayment. The timing of those two, the modification came in 2019, the wage underpayment came in 2020. So there's an inference that he was paid the correct wage from 2019 until April of 2020. And then there's allegations of breach in paragraph 18 and 20, also on record page 34. My apologies, Your Honors. With respect to that proposition of law that I recited, the cases that stand for that are Carroll versus Clark, 129 AD 2D 773, and Woodard Reliance World Ward Corp. It's a Southern District of New York case, 18 CV 9058. Those were not cited in the brief. They are in response to an argument raised by defendant in reply. Unless the court has any further questions, we would ask for affirmance in all respects.
Can you address the point as to whether or not you have the right to unilaterally reduce plaintiff's salary? Because you say because it's an at-will employment relationship, you just do. Is that right?
No.
So what's the
Not
basis?
exactly. So it's an at-will employment relationship that is admitted to be an at-will employment relationship by the plaintiff in numerous places throughout the record, as well as the fact that...
So then how is it that you believe you have the unilateral right to reduce the salary?
Based on the terms of the contract, an at-will employment relationship is if there is no fixed duration for the contract, that's considered an at-will employment relationship. And at-will employment relationships are determined to allow the company to modify.
So in other words, your answer is yes. Because it's an at-will relationship, you have the right to reduce the salary.
And because the terms of the contract reflect an at-will relationship. Can I address just that paragraph 12 of the agreement, the merger clause also has a no oral modification clause, which requires a signed writing by both parties to modify the contract. So the allegation that $75 an hour was an amendment to the contract is not, cannot succeed.
Okay, thank you. Thank you both. People versus Wallace. You may proceed, counsel.
Good afternoon, Your Honors. Robin Richardson with the Legal Aid Society on behalf of Mr. Wallace. I'm here.
Counsel, let's just start off, because I understand that your whole argument is based on the Kroll decision in terms of whether or not Factor 12 can be assessed. But the facts under Kroll were so specific, right? You know, there was this person who had testified at his trial. He had written letters to probation, to docs. He was under the advice of counsel that he had a pending appeal and he couldn't admit to certain things. And he was invoking this right to self-incrimination. Subsequently, our court has decided maybe two other cases, Rivera and Williams, which kind of go in different directions. But the bottom line is, how did the defendant invoke that Fifth Amendment right, or does the record reflect it? Here, is he really denying or invoking the Fifth Amendment right, or is he explaining away what happened?
Your Honor, he does invoke his Fifth Amendment rights during the SOAR hearing, at the SOAR hearing that does happen. And in this case, he does also have a pending appeal, and he did deny
What does he say at the SOAR hearing to invoke his rights?
I can look it up. He does. Oh, I'm sorry, I'm in the wrong position.
No, you might want to do it. You might.
I could do it at the.
Do it, yeah, because your time is running.
Of course.
So do it when and respond in reply.
For sure. Thank you.
Okay, so that's one element, and then the second element is here. Of course, he didn't testify at trial. So what? How should we consider that element?
Well, this court in Williams did not require the defendant to testify in trial. And really the issue here under the Fifth Amendment is that requiring the defendant to accept responsibility could potentially result in his admissions being used against him in any retrial. That is the crux here. He has a pending appeal, and he may want to assert his innocence in his appeal. So whether or not he could,
assuming he's asserted it in the first place, right?
His position throughout the trial was that the touching was misunderstood.
Right. That it was misunderstood, not that it didn't happen. So that's almost like shifting the focus of intent. They misinterpreted his intent, right? But he didn't deny, as far as I can tell, the touching. So is it really, did he invoke his Fifth Amendment rights against self-incrimination?
Yes, because in order to find him guilty, he has to be guilty of an intent for the touching. It can't be just a brush or a, there.
I get that, but I'm not sure that you're understanding my point, right? It's he didn't just remain silent. He spoke, and he said they misinterpreted what I did. That's not saying I didn't do it. There's a difference.
There is a difference, but it's still him asserting his innocence and having him accept his responsibility. And I think what the court is asking here.
Well, the difference is the distinction is between asserting his innocence, right, and accepting responsibility. And there's a distinction to be made there. When one invokes the Fifth Amendment right, they're just remaining silent. What he is doing is he's not accepting responsibility. There's a difference. There's a distinction there.
And in this case, the SOAR court actually said in assigning these points or assessing these points that the reason why he was assessing the points was that throughout the trial, defendant testified under oath, I didn't do this, it never happened, and the jury did not believe him, and I am now assessing 10 points under this. So this was essentially putting him in this impossible, as this court has said, Hobbesian choice of either becoming a level 3, because these 10 points are the difference between a level 2 and a level 3, or waiving his right.
I don't know, counsel, because I think that the way that you want us to now interpret it would require some sort of expansion, because again, as was throughout the Kroll decision, it was very specific and as to what the defendant had said, how he initiated his Fifth Amendment rights, and I just thought we don't have any of that here, right? Other than the statement at the SORA hearing, they misunderstood what I was doing.
Well, the SOAR court, how Mr. Wallace effectuates his defense is between him and his defense attorney. It's not up to the SOAR court to then limit it, to make it impossible for him to.
But what's important is that we're able to glean from the record that he asserted his Fifth Amendment right. That's what's important.
And I believe he did do that.
And you're gonna.
I will look it up. Thank you.
Thank you very much.
Good afternoon, and may it please the court, Catherine Murata for the people.
I mean, counsel, the flip side of this whole argument is that where someone is saying, it didn't happen that way, I didn't do it, what's really the difference between those two things?
Well, I think that the Kroll analysis does not apply here at all. Most notably, defendant pleaded guilty to one count of forcible touching. And the Kroll court did say that the Kroll analysis does not even apply when defendant's denial of responsibility was made despite his guilty plea. So I think that's important to note. As far as his statements, he is essentially deflecting the blame onto his victims, shifting responsibility onto.
Well, but that's not what he's saying. Isn't it what he's saying is I'm a personal trainer and there's some consensual touching as a personal trainer doing the various exercises. And that was misunderstood. Isn't that what he's saying?
His statement was basically, yes, that he, as a personal trainer, he had to get close to his clients and they misunderstood.
But he didn't deny the level of closeness that he had to get to his client. For example, biting someone's intimate part. You don't need to do that as a personal trainer.
No, he didn't deny getting close. He basically just tried to, described the misconduct but shifted entire blame onto his victims. And I think that for Kroll to apply, also, as you noted in Kroll, the defendant in Kroll denied his guilt repeatedly and adamantly in anticipation of future litigation for his appeal. He was adamant that he was bringing this appeal.
Yeah, but we also said there that there's really no, you can't, we're not going to quantify how someone invokes their Fifth Amendment right. That was part of the Kroll decision. And I guess the issue here might be, well, what is sufficient? The way that he invoked it in this case, is that the bare minimum, or by saying, well, it didn't happen that way? the fact that he didn't testify, isn't that him just invoking his Fifth Amendment rights just off the bat? I mean, that's his constitutional right. So where do we draw that line? How far do we go with Kroll?
I think it's hard to quantify what exactly is invoking the Fifth Amendment right, but I think under these circumstances, the record does not support that he invoked his Fifth.
Let's assume, and I don't know what your adversary is going to pull up, maybe a rabbit in a hat, but let's assume that at the SORA hearing, there was an invocation of the Fifth Amendment right. Is that sufficient then, at that point?
Well, I believe at the SORA hearing, the only thing that was said was his counsel argued against the points being assessed.
No, I'm just asking you, would that be sufficient? If we find that it was the Fifth Amendment right was invoked at the SORA hearing, is that sufficient under Kroll?
No, I don't believe that is sufficient. I think he has to have an affirmative statement, but also has to be a nexus between the statements and some kind of future litigation, pending appeal.
Well, there is pending appeal, right? Here.
There is a pending appeal here, but at the time of the statements that were made, unlike the defendant in Kroll, he wasn't as adamant in his desire to bring the appeal or future litigation. In Kroll, he said he denied his guilt because on advice of counsel, he was going to bring the appeal in the PSR. He reiterated that at docs, even in the sex offender treatment, he was very adamant that he denied his guilt. Here, he's just kind of shifting blame with no anticipation of future litigation or the appeal. And just to note about the pending appeal also, even though there is a pending appeal here, it's been 5 years since he has filed his notice of appeal in August 2019. So it's almost, like the vast majority of defendants, he has filed a notice of appeal. And I think to use that as a way to escape an assessment of points under Factor 12 is too broad. And I think here the record does not support that he invoked his Fifth Amendment right against self-incrimination. Also, he did not testify at trial, and I believe his pending appeal it's been 5 years since he filed his notice of appeal. So I think taking those together, the Kroll analysis does not apply in this case, and he was properly assessed.
Counsel, just very briefly, can you address defendant's argument that challenges the assessment of points under risk factor 7 regarding the professional relationship with the victims?
Sure. So defendant was assessed 20 points under factor 7 for the abuse of professional relationship. As a personal trainer, he used his job to prey on his victims, isolate them in vulnerable positions at his private one-on-one training sessions with them, and sexually abuse them. So he used his status and he exploited the relationship. They put their trust in him, and he exploited their trust. He also used his status as a personal trainer to prey on them, but also as a way to deny his guilt and act like this was just, a normal part of the training session. So he was properly assessed points under factor 7 as well.
Thank you, counsel.
Thank you. Okay.
I anticipated the question about the record, and I'd actually even circled it. So it's on page 22 of the hearing note or the hearing minutes, where defense counsel argued.
Oh, so SORA, right?
Yes, Your Honor.
Oh, SORA. So you concede SORA is the first time, putting aside the issue of what happened at trial, is that there was an invocation of Fifth Amendment rights?
Yes, Your Honor, and that, for the purpose of SORA and the purpose of those 10 points under Factor 12, is exactly where he needs to assert those Fifth Amendment rights.
But is that what the Kroll decision holds?
The Kroll decision holds that
Because in Kroll, there had been, before the SORA hearing, there had been multiple times where he invoked his Fifth Amendment right. That's not what happened here. Why in of itself does that just not take this case out of the Kroll analysis?
Well, because he's still asserting his Fifth Amendment rights. He's whether.
And there's an appeal pending, but so to counsel's point, so there's no appeal perfected for 10 years.
For 5 years. But
well, we continue in this fashion. I mean, there seems to be an issue there, right?
So the case, I did check up on this. The case has been assigned to legal aid. I'm sure Your Honors are aware of the legal aid backlog. Mr. Wallace is an indigent defendant, and it is not his fault that this case has not been perfected, and it should not be held against him.
Fair enough.
Regarding the guilty plea that he had, that is one guilty plea that he made to a separate indictment after his trial. The fact that he pled guilty to one case should not waive his Fifth Amendment rights as to the other 6 charges, which he still has a pending appeal for, which he did assert his right against self-incrimination and did go to trial on.
Counsel, can you respond to the argument that defendant used his, status as a personal trainer to, isolate the victims, have access to them, and sexually abuse them? Can you respond to that?
As to the points under Factor 7, I am just resting on my brief.
Okay.
Lastly, no, that's it, actually. I request that the court reduce his RAI score and adjudicate Mr. Wallace a level 2. Thank you very much.
Thank you, counsel. Thank you both. Wells Fargo. Want to note again, Judge Michael is recused.
With the court's permission, we filed our appeal first, but we had a discussion with some of the other appellants, and they've asked to go first, and we're fine with that. Okay.
Not a problem.
Thank you, Your Honor. Good afternoon, and may it please the court. Justin Ellis for the Joint Appellant Group. This may be a complex case, but this appeal is very simple. This is a dispute about how certain contracts treat mortgage payments whose due dates have been deferred. Without parsing the contracts or reading the parties' merits briefs, the trial court granted relief nobody asked for. It held...
Are you saying, in essence, that the court granted summary judgment when no one was looking for summary judgment?
Correct. And it would have been entitled to grant summary judgment under 409B had it parsed the record. That's what it means by the requirement pleadings, proceedings, and papers in 409B, but it didn't do that. It decided the case improperly on a truncated record. It also just got the facts wrong. There are 3 simple facts showing that. 1, JPM2 said nothing about deferred principal payments. 2, everyone here today agrees that the contract's definitions of subsequent recoveries are unambiguous. And 3, under those definitions, deferred principal payments aren't subsequent recoveries. I'll take each in turn. First, JPM2. There's a reason the words deferred principal don't appear in JPM2. Those funds just weren't at issue in that case. JPM2 was about a settlement agreement, and that agreement dictated that the settlement payment were subsequent recoveries, no matter what the contract said. JPM2 did not decide what are and are not subsequent recoveries. This is an issue of first impression under the contracts. Point 2, every party agrees that the contract's subsequent recoveries definition is unambiguous. So extrinsic evidence, such as course of performance, just doesn't matter for this appeal. All that matters is the contract's plain text. And that leads to my third point. Under the contracts, deferred principal payments cannot be subsequent recoveries. There is a simple reason why. The definition of subsequent recoveries only covers money that is specifically related to a liquidated mortgage loan. A liquidated mortgage loan is a dead loan. The loan is extinguished, and the borrower owes nothing more on that loan. But these loans aren't dead. The borrowers owe payments, and they're making payments. The only change is that the due dates for certain payments have been deferred. But we're here because we're fighting about what to do with these payments. There are almost $400 million of past and future deferred payments at stake. Now, respondents claim that modified loans are what they call partially liquidated. But it's not up to respondents. Their theory can't fit the contracts for 2 reasons. First, a loan is a liquidated mortgage loan, a defined term, only if all of the loan is unrecoverable. Again, that can't be true here. These borrowers are making their payments.
Does HAMP resolve any of these the ambiguities in these provisions?
Well, there are no ambiguities, first of all, in the definitions of liquidated mortgage loan and subsequent recovery. And no party to this appeal argues that there are. But second, to your question, HAMP did not change the definition of subsequent recovery. That word does not appear in the HAMP guidelines, nor does HAMP change the definition of liquidated mortgage loan. And that distinction is important because Treasury knew what it was doing. When it wanted to suggest that servicers or trustees should act differently than what the contracts provided, it said so. It used defined terms. And even more importantly, it granted them a safe harbor for liability in case they were sued for acting differently from the contracts. But they did not use the term subsequent recoveries, and they did not grant a safe harbor for treating things as subsequent recoveries. After all, that's why my colleague, Mr. Pierce, is arguing so strenuously for a good faith instruction, because his client, the trustee, didn't get a safe harbor under the statute for treating things as subsequent recoveries. There's just no provision for that in HAMP. Respondents also refer to a language in a few trusts that refers to partial liquidations. Briefly, I just want to note the vast majority of trusts don't use that language, but respondents are missing that point. That language does not change the definition of liquidated mortgage loans. Only wholly liquidated loans, again, dead loans, meet the definition of liquidated mortgage loans. So under the contracts, these payments are not subsequent recoveries. So how should they be treated? Well, the only way to answer that question is a trial. The parties had 2 years of discovery here, numerous expert reports, voluminous discovery taken. The trial court never parsed that record. When complex factual questions like this haven't been answered below, this court's consistent practice is to remand so the trial court can answer those questions in the first instance. That's what the court should do here.
So it's your view that we shouldn't even address the merits, that we should just remand it? Or do you want us to address the merits here?
You can and should hold that deferred principal payments are not subsequent recoveries. That is clear under the plain text of the contract. The rest of this dispute should be remanded to the trial court for a trial.
Anything else, counsel?
No, I'll reserve the rest of my time for rebuttal. Thank you.
May it please the court, Sam Lieberman of Sadis and Goldberg on behalf of counter-petitioners appellants, the Deer Park Group. We argue to raise two separate points that address fundamental errors by the trial court on top of what my brother, Mr. Ellis, has just shared with the court. You know, the fundamental point is that the trial court never addressed counter-petitioners' distinct argument that unpaid deferred principal balances should be included in the monthly over-collateralization amount calculation under the plain language of the agreement. And respectfully, the trial court simply whiffed on this issue. We raised the point to the court acknowledged we made this argument, but the court never addressed it. The court addressed in the situation when there's an actual deferred principal payment.
Does HAMP guidance from, does that deal with the issue of deferred principal?
What HAMP addresses is that foreborn principal can be treated as a realized loss if there's no other language, a realized loss to the trust, if there's no other language saying otherwise in the pooling and servicing agreement. But what's important, and Justice Singh, you just previewed my next point, which is going to be HAMP guidance does not address subsequent recoveries. It doesn't use the term subsequent recoveries.
But it does address realized loss, and isn't that enough basis to say that you're wrong on the over-collateralization argument that you're making here?
Oh, no, it's not. And the reason is because over-collateralization is based on the principal balance of the mortgage loans. And HAMP, in fact, does not say that it's a loss to the mortgage loans. HAMP says, in fact, the exact opposite. HAMP says at JA 10121, it says that principal forbearance remains fully due and payable at the end of the loan. It actually says even further in JA 10124 that the gross UPB, unpaid principal balance of a mortgage loan, includes any principal forbearance amount. And the reason we raised the point about over-collateralization is that there's a difference between the collateral for the trust, that's the loans, and the actual trust securities balance. These trusts are designed, when they have an OC structure, to have more loans than the actual value of the securities, and that's to protect against losses. And in fact, the problem here is that by not recognizing this distinction, the trustee, the trust is not recognizing the protections against losses that senior certificate holders have. As the JPM order that the court below cited actually acknowledges, OC is a buffer against loss, and in an OC structured trust, it's designed to have higher principal balances of loans than the actual certificate balances. We have that situation here, and in the over-collateralization amount definition, it's clear there's only one thing that could subtract from the principal balance of a mortgage loan on any given month. So let's say we're in 2024 with a $200,000 loan. There's only one thing that could be subtracted from that. That would be a loss incurred in that month. That means that a loss to the trust from 10 years earlier on a modification cannot be used to subtract it. That would actually read out the language for realized losses that says only losses incurred during the related prepayment period, which is defined as from the prior calendar month. In doing so, therefore it would violate, as you mentioned, Justice Singh, a cardinal rule of contract interpretation in the IKB dissent, where you noted to have a term, losses incurred during the related prepayment period, and actually read that language out of the OC definition. So the point we make here is that no, HAMP gives no instruction to save the trial court's decision. And in fact, because HAMP doesn't address this particular situation, it doesn't mention over-collateralization, doesn't mention subsequent recoveries, doesn't mention liquidated mortgage loans. They try to shoehorn other language in. They cite some FAQ that uses different language, but that doesn't use the term subsequent recovery. It doesn't mention over-collateralization. And that's what my brother Ellis was trying to tell you, which is this is an issue of first impression. And what it really deserves is to have the trial court in this $400 million dispute go through the language of the definitions, apply the language of that definition, and render a reasoned decision. And I can say standing here that at this moment, I don't think the litigants really understand what the trial court was doing below. That requires a reversal and remand for further proceedings in this case.
But couldn't we also maybe say, assuming that we maybe do or do not agree with you, that because of all of this confusion or whatever the trial court didn't address, there are issues of fact that exist. So you're not going to get your way regardless, right? We're not going to rule. It's issues of fact. We don't know one way or the other, because I don't necessarily know if you can say that that there are no ambiguities when it comes to defining what the subsequent recoveries are in terms of the deferred principal payments and how that all plays into HAMP.
Well, Justice Pitberg, I think that, look, our position is that the language is clear. But what this court could say is that despite the language being clear, there are some factual underpinnings that are needed for the trial court to sift through to address it. For example, the trial court did not address the text of the HAMP modification agreements, which say that deferred principal should be treated as part of the principal balance. The trial court did not address other extrinsic evidence with any significant analysis. So I think that is room for the court to say that, okay, the court could address the definitions, or it could say to the trial court, well, go back and apply the definitions to the facts that are in the record. There are a lot of facts in the record that could use sifting through.
Thank you, counsel.
All right, I'll reserve the rest of my time.
May it please the court, Clay Pierce on behalf of Petitioner Wells Fargo. Your Honors, just 3 quick points. 2 on the issue of good faith, 1 on the issue of subsequent recoveries. Point number 1, no one disputes that the lower court applied the wrong test in assessing the trustee's good faith. There are decades of precedent from this court and the Court of Appeals that makes it crystal clear the question of whether a trustee acted in good faith requires a court to examine the trustee's motives and the trustee's subjective intent.
Oh, is that something that can be done on a cold record as opposed to a trial?
Well, Your Honor, we believe that this court, based on the record evidence that was introduced below, which is unrefuted as to the trustee's good faith, can rule.
So in essence, you're saying that you're entitled to summary judgment. I mean, isn't that, the underlying complaint here is that the trial court went much further than it had to on the motions in limine. And that in essence, what you're asking is for a summary judgment then from us.
Well, what we're asking first, Your Honor, is that you reverse the lower court's ruling on good faith because it was based on a misreading of JPM.
So the question is then, what more beyond reversing, if that's what we're inclined to do, you're asking for?
I
Would
think
there
that the
be
court,
a trial on the issue of good faith?
right, Your Honor, I think that the court needs to make clear to the lower court that good faith requires an inquiry into motive and state of mind. We've given you a lot of law on this, and none of that law was taken into account by the lower court. The question that you're getting at, if I understand you, number 3, is whether or not we have to have a trial on good faith or not. The point that I'm making is that no one in this room has come forward with any evidence that indicates we had a financial conflict, that we were
But again, there's no motion for summary judgment here. There's no motion, presumably, because it was too late to make a motion for summary judgment, right?
There is no motion for summary judgment. We did not move for summary judgment.
Right, so these are issues, so aren't these issues of fact as to the trustee's good faith meant for a hearing or a trial?
Your Honor, I'm not going to say that this court committed error if it remands for trial on the good faith issue, but I don't think that would not be error, but I do believe there is enough evidence in the record for you to rule in our good faith here. If the court chooses not to do that and we have a trial, that's fine by us. Here's the point that I wanted to make on subsequent recoveries. I heard my learned adversary say that there is no one thinks that the subsequent recovery definition is ambiguous. That's not true. The reason why we're here is because things happened that no one foresaw when these contracts were written. No one knew that the mortgage market was going to melt down. No one knew that the Treasury Department was going to instruct that for these particular kind of modified loans, we would take realized losses even though the loans are not dead, as my adversary said. And the fact that the HAMP guidelines say that you have to take realized losses, that necessarily implicates the definition of liquidated mortgage loans, because under the contracts, you can't take a realized loss if they were not liquidated mortgage loans. So the fact that they took the realized losses, that means we've committed. The Treasury Department was instructing us to treat these things as though they were liquidated mortgage loans, and to change course now, that doesn't make any sense at all. That would result in
Didn't HAMP address treatment of principal balance at the time of the modification?
I didn't hear your question.
Didn't HAMP address treatment of, at the time of the modification, initially?
What the Treasury instructed trustee parties and servicer parties to treat deferred principal amounts as losses. And if they're losses under the contracts, that means that you're treating these loans as though they are liquidated. And that is the reason why when those same amounts were repaid, we treated them as subsequent recoveries. My adversary says, read the definitions. I agree. Read the definitions. You'll see that subsequent recoveries and realized losses, they're inextricably intertwined. If these dollars were written off as losses back at the time of the modification and they get repaid, they're subsequent recoveries. The point that I would make, Your Honor, is that the arguments that are being made by my adversaries, they're asking you to rule right here and now that deferred principal payments are not subsequent recoveries. Please don't do that. I don't think that it's supported by the contracts. I don't think it's supported by the record. I disagree with their arguments on ambiguity. I think that the contracts are not clear about how to treat deferred loans. I think that the clarity was added by Treasury. What's really clear in the contracts, though, is that if it was a realized loss at the time of the deferral, it has to be a subsequent recovery when those amounts are repaid. And on that note, I'll stop. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. HAMP does address the subsequent recovery issue. What the HAMP guidelines say is that for loans within securitizations, principal forbearance should be passed through as a write-off of principal to the securitization trust, with any future collections at the time of payoff submitted to the trust as a principal recovery. Now, principal recovery is not subsequent recovery, but it means the same thing. And the reason they didn't specifically use subsequent recovery is that not every securitization agreement uses that term. But principal recovery is crystal clear. Now, I think as Mr. Lieberman may have...
Wouldn't that be an issue for trial as opposed to us deciding that as a matter of law here?
I don't think so, Your Honor. I think this is very similar to what happened in the JP Morgan case, where this court looked at the settlement agreement that was at issue there. That was not an amendment to the PSAs and was not fully by the parties to the PSAs. It was negotiated by investors and JP Morgan. But that agreement specified how the settlement payment should be distributed to the trust, to all of the trusts. It said the settlement payment itself should be treated as though it was a subsequent recovery, and it provided distribution provisions that specified how the settlement payment should be distributed to certificate holders where the PSAs were silent. And the court embraced that proposition. Those gap fillers were used and endorsed by the court. HAMP works in a very similar way. HAMP says when you do the modification, you treat the deferred principal as a realized loss. No one disputes that. And if the money comes back in, you treat the money as a principal recovery. Now, under these agreements, that's a subsequent recovery. And so, I mean, just like the settlement agreement specified how to apply the settlement payment to these trusts, the HAMP guidelines provide that same guidance. And whether it's a gap filler or a requirement of HAMP itself, none of that is inconsistent with the terms in the PSA. Now, as Mr. Ellis acknowledged, some of these PSAs contemplate partial and complete.
But the bulk don't. You would agree with that, right? Most don't.
That's true, but it's an acknowledgement that they've only made recently. In their opening briefs, Deer Park said there's no such thing as a partial liquidation. And we point to those provisions in some of those PSAs just to highlight the fact that at the time these PSAs were drafted, all of them were drafted, partial liquidations were a recognized concept. And so when the subsequent recovery definition says that the amounts have to come in after a loan is liquidated, and that's an unmodified term in that subsequent recovery definition, that necessarily includes both complete and partial liquidations. So we believe that the court was correct that HAMP really dictates the result here. I'd also like to briefly address the proposition that the lower court did not address Deer Park's over-collateralization argument. That's mistaken. He identified it, he rejected it, and this was a primary reason why the court highlighted its prior ruling in the Deer Park versus Nation Star case. Now, in that case, the court held that deferred principal should be included in the termination price because the HAMP guidelines instruct that deferred principal is treated as a realized loss only, quote, for purposes of calculating distributions to certificate holders, unquote. The termination price is a price paid for all of the remaining mortgage loans when a trust is terminated early. It's not part of the monthly distribution calculations. The over-collateralization amount is part of those monthly distribution calculations. That's one of the key ways you know which waterfall provision the money should flow through. And so for that reason, HAMP would say, treat that as a realized loss. PSAs are completely consistent with that proposition because, and I guess I should preface this, Deer Park's underlying argument is that, sure, treat the deferred principal as a realized loss when the modification is done. But after that month, the month in which that realized loss is incurred and applied to the loans, just treat it as if it never existed, so that the mortgage loan balances just are propped right back up. What HAMP is saying is that for those monthly calculations that determine who gets paid what and under what provisions of the PSA, those amounts are realized losses, and so they cannot be included in the aggregate loan principal balance for purposes of calculating the over-collateralization amount.
Thank you, counsel.
Thank you.
4 very brief points in rebuttal, Your Honor. First, my colleague, Mr. Pierce, claims that everything that reverses a realized loss must be a subsequent recovery. That's not true. That's not what the definitions say. It says it has to be something reversing a realized loss for a liquidated mortgage loan. He does not grapple with that language. Nor did HAMP say that these loans must be liquidated loans. In fact, if you look at page 10121 of the HAMP guidelines in the record, it says that these loans are fully due and payable. They are not liquidated. At any rate, the trustee did not treat these loans as liquidated. It recognized in its internal policy interim position 55 at page 10720 in the record that these loans were active. It didn't even think these funds were necessarily subsequent recoveries. It just said for purposes of its internal modeling software to treat them in the same manner as subsequent recoveries. In fact, it has treated them as something else than subsequent recoveries. It's treated them in the past as principal prepayments. 2, my colleague Mr. Sheaf says that because of that FEQ referring to principal recoveries, that you must treat these things as subsequent recoveries. He admits it does not use the defined term subsequent recovery. And as I discussed, there's a reason Treasury does not use that defined language. All Treasury meant was to treat these funds as principal rather than interest, because that's what they were. They were principal. And if there's any analog to the terms principal recovery in the PSAs, it's principal prepayment. If you look at the definition of principal prepayment, that's where you use the word recovery of principal. 3, there's the reference again to partial liquidations. Whatever a partial liquidation is, there's no such thing as a partially liquidated loan. A liquidated mortgage loan is one defined as where all amounts are unrecoverable. We are recovering amounts. These cannot be liquidated loans. And finally, the question was raised whether there may be issues of fact here that render these ambiguous. Well, this is a situation where every party here has argued, in fact, that these issues should be decided on the text of the contract. The parties may violently disagree about what the contracts mean, but that does not make the contracts ambiguous. You should and can hold that deferred principal payments are not subsequent recoveries. You should remand the rest for trial. Thank you.
Thank you.
Thank you, Your Honors. Just a couple of points. First of all, Mr. Sheaf actually misread Justice Barak's reference to a prior decision when he's talking about over-collateralization. I invite you to read. You have the decision in front of you from the termination price case. The court never uses the word over-collateralization. In fact, in Respondent's Appendix, you can see the court actually said the opposite with respect to this case. The court looked at the HAMP guidance and said that it doesn't say it is no longer outstanding and pursuant to the mortgage loan itself. This is RA, Respondent's Exhibit. This is 34, lines 11 through 13. In fact, Justice Barak reached the opposite conclusion, that these amounts are still outstanding on the loan as opposed to the securitization. His conclusion was that the HAMP footnote only says that deferred principal is no longer amortizing. He said the opposite. So there's nothing in his reference to the other decision that addresses over-collateralization. As to, I echo Mr. Ellis's point about principal recovery. As Justice Singh noted, yes, someone should actually go in and figure out what that really means, because recovery of principal at JA 5704 is identified under the definition of a principal prepayment. As to the Wells Fargo position, although we think that the subsequent recovery language is clear, if they're saying it's ambiguous, then that would require a remand regardless. Again, we think the language is clear and the court would do a service to the parties by addressing these issues. But really, I think at the end of the day is you can read the decision yourself and you can see what the court did and did not address. We have a court that actually overread the JPM decision that doesn't address it. It didn't engage the over-collateralization definition for unpaid amounts. And we think that cries out for a reversal and remand here so the parties can get the trial they deserve on this issue of first impression. So unless there are any other further questions, we argue for reverse and remand. Thank you.
You have a cross? Do you have a cross appeal?
We oppose some of the points that made by. Okay.
No. Simon. You may proceed, counsel, when you're ready.
Good afternoon, Your Honors. Douglas Siegel for appellants. You have a situation here where it's undisputed that the lower court made certain basic mistakes. For example, when describing the investment memorandum's assertion regarding the past historical facts, his past historical rates, the lower court described that as being as being a statement, as it being a projection. That's not a projection. When someone says a portfolio's historical natural turnover rate, by definition, that's a statement of fact as to what happened in the past. In no way, shape, or form can that be described as a projection. The respondents don't deny that the lower court simply misunderstood that the difference, that the assertion regarding the property's historical natural rate was not a projection. That's A. B, the lower court, when they said,
So, but rather than attacking the lower court's decision, why don't you tell me what are the facts that you allege that that support defendant's knowledge of the falsity of the statements in the offering, especially with respect to the to the underwriter assumptions?
well, the underwriting assumptions, they said that in order for this investment, in order for the business plan to make any sense, what they said is that the respondents said is that 20 non-home agreements, apartments, have to be vacated each year. That has to happen in order for this to make sense. And this is what happened in the past. Each year, on average, I think they say 23, or I think they say more than 20. No, it's on average 20 units each year. 20 apartments which were not subject to the home written agreement were vacated each year. It's just not, which was not true. It's not true. So that's a clear statement of fact of what happened in the past, and it's not true. They made further false statements. They made further false statements about the values of the apartments. Now you have to understand, the appellants here had no access to the apartment. They had no privity with the seller. They weren't a party to the contract. They had no way to evaluate these apartments for themselves. The only way.
Let me just ask this question then. In terms of the investors themselves, is there anything in the sophisticated investor limited portion of the limited partnership that might affect your argument?
I'm not sure I understand the question, Your Honor.
So is there any way that we can view the record before us that maybe you should have done a little bit more diligence in before you entered into this venture?
We cannot have, Your Honor, and this is actually in the complaint. And the reason why we cannot have is, besides the fact that the investors were overseas, they had no privity to the sellers. They had no contract with it, and they have no contractual privity. They had no way to access the apartments. They had no way to evaluate it. The only way that they could evaluate this investment was through the investment memorandum. They had no independent access. They had no papers. They had no blueprints for the property.
But then how do we sort of, going to in the limited partnership agreement, that's what my colleague I think is getting to, are statements that you're sophisticated investors with knowledge, making independent decisions to invest, et cetera, et cetera.
That's true, but if that's the case, why are the respondents submitting an investment memo? The reason why they give an investment memo is precisely for the investors to rely on. Now, it's true that the partnership agreement did have boilerplate disclaimers, I'm a sophisticated investor, et cetera, but those are clearly for SEC purposes. We're talking about meeting certain guidelines of when you could invest.
I mean, it goes on, it's not just that we're sophisticated investors, it goes on to say that they don't require any other information or data relating to the investment. How do you turn around now and say that, well, they didn't give it to us, you didn't ask for it, you didn't want it, at least based upon this language?
The law is, excuse me, Your Honor, the law is clear that if for disclaimers to preclude a claim, it has to be specific to the fraud at issue, the misrepresentation at issue herein. You can't just have a blanket disclaimer saying, well, you're sophisticated and therefore you don't need anything more. If they wanted to rely on that, what they should have said is, yeah, we have all these numbers here, don't rely on my numbers, even though I say here that the historical rate is X. Don't rely on me when I say the historical rate is X. But they didn't say that because they knew if they say, don't rely on me when I tell you, when I represent the property's historical rate, no one's going to invest. When they say, they knew if they said, don't rely on me when I tell you that 3-bedroom apartments in this neighborhood of this type and this quality are worth Y, if they said that, no one would rely on that. And that's precisely why the courts in New York have repeatedly said that in order for a disclaimer to have any weight to preclude a claim, it has to be specific. Because if it's not specific, then it's just besides the point. I don't know if that addresses the court's question, but that's precisely why these generalized disclaimers, which are clearly drafted to address SEC requirements, cannot preclude the claims of the misrepresentations that are issued herein. The fact is that if respondents had the way and the lower courts followed, basically anyone who invests in real estate, they're completely vulnerable to any type of manipulation or misrepresentations or anything of that ilk, because they have no independent way to verify this information. They're relying only upon this investment memorandum, and everyone knows the investment memorandum is specifically drafted to lure investors in. That's what it's for. The whole point is to lure investors in. If you basically say, well, you should have done more homework, even though you don't have access to the apartments or to any of the history, then bad actors are given free rein to say whatever they want in an investment memo. Otherwise, what's to stop an investment memo? Even if they want, presuming they wanted to defraud, what's to stop them? They will never be called on the carpet for that. I think this also goes on. I reserve my time for rebuttal, Your Honors.
Good afternoon, Your Honors. I'm Jenny Gu from Schindler, Cohen, Hochman. I represent respondents. This court should affirm the trial court's dismissal of this case because plaintiffs haven't alleged any elements of fraud or negligent misrepresentation.
How about with respect to the natural turnover rate of your portfolio? I mean, that's knowledge that you possess, they don't possess. So what more can they say about it?
Well, they need to have some basis for saying that this rate is false. I mean, this court has held time and again that you can't just come in and baldly assert this statement is false. You have to allege some facts that allow the court to draw an inference that the rate is false, and they haven't done that.
What were the allegations to say that they're false? I mean, what was that based on? Can you point us to particular paragraphs where they say it's false because?
Well, they don't have that. They don't allege that at all.
They allege that it was on information and belief only?
This one was not on information and belief, but they said it's false that the turnover rate was, accurately represented in the investment memo, but they don't say why. They don't say what the real rate is. They don't say how they
If it's your
determine that.
portfolio rate, how would they be able to say it? I understand the argument with respect to the average market price of a 3-bedroom apartment in the unit. You can get brokers and do all that kind of stuff to figure that. That's not knowledge peculiar to defendants. So with respect to knowledge that's peculiar to you, what more can they say than information and belief?
Well, they need to have some factual basis. For example, like based on our research of XYZ, this portfolio has a turnover rate of a different number. And I submit that they couldn't say that because actually the investment memo and the project business plan make clear that the turnover rate does take into consideration the home program, which is their chief complaint, right? Their chief complaint is, well, your turnover rate doesn't take into consideration that a number of apartments in this portfolio were subject to the home program and wouldn't be eligible for upgrades until 2018. But as Justice Cohen points out, the investment memo itself disclosed that these apartments would not be eligible for renovation until 2018. So clearly this was taken into consideration. And then the business plan that's included with the limited partnership agreement, it describes, like 20 apartments in the first 3 years would be renovated. This is specifically excluding the home apartments. And thereafter, you would have 40 apartments for the 4th year when you can take those apartments into consideration. So they can't allege that we didn't take those into consideration.
Or that they didn't have knowledge of it because it was in a portfolio, right?
Precisely, yeah. And that's a huge problem with their complaint as well, the reliance portion. As Your Honors point out, they represented that they had all the information they needed and that they were sophisticated investors.
Well, you heard your adversary say that that's boilerplate, it's for regulatory authorities. Is that the law here of the state?
No, it's absolutely not boilerplate. I mean, first of all, they could have asked for more information, like the floor plans and things like that, right? And second of all, the investment memo, again, disclosed exactly how many apartments were eligible for upgrades before 2018, after 2018, which is their chief complaint. It also disclosed that the renovation projections may not pan out because the building was old. It disclosed that the project was heavily leveraged and therefore very risky. So these are not boilerplate warnings. And despite these warnings, plaintiffs didn't ask for any additional information and they invested. Chiefly, this is a fraud by hindsight kind of case. Essentially, they're arguing that the projections failed, so that's why it's fraud. But they've not been able to allege any other independent facts beyond the failed projections to show that we lied about anything. So for those reasons, the fraud, negligent misrepresentation claims fail. And then just briefly, they've alleged two other claims, breach of fiduciary duty and gross negligence. Both of those are based on the fraud claims. And if there are no actionable misrepresentations, then those claims also fail. So for those reasons and those discussed in our papers, we think the court should affirm the dismissal of this case. I'm happy to answer any questions.
Thank you, counsel.
Thank you.
If I may, Your Honors. What my esteemed adversary just said actually supports Appellant's argument. Because when she presents the specific disclaimers that presumably preclude Appellant's claim, they have nothing to do with the facts at issue here. So for example, one of the specific disclaimers—
But it was responding. I think one of your points was that you didn't have the information, you didn't have documents, overseas investors, and what my colleague was pointing out to you, that in fact there's a partnership agreement that sort of runs counter to what you're saying. That's all. So address the argument that you other than bare bones allegation that the natural turnover rate is false, you don't really do anything more.
That's not true, Your Honor, with all due respect.
Okay, so what do you do? What do you say?
What I'm able to do is I point to subsequent history of the property to point out how far off it was. So we basically recite to what actually happened. So for example—
But that's sort of like, that's hindsight, isn't it? I mean, the investment fails, and then you look to see where all the failures are and say that's—
Well, if that's the case, Your Honor, then any investor should always give up right now for ever bringing a claim of fraud, because they'll never have the information from the beginning to show that what happened beforehand. In other words, what the court is saying is, if you investors want to bring a claim for fraud, you have to have the information in hand from before the investment, which of course they're never going to have, ever, because apartments in New York's apartment buildings is
Couldn't you, for example, have put in some allegations or evidence in your complaint with respect to what the natural turnover rate of property in the area is?
I can't do that, Your Honor, because this property, as disclosed in the investment memo, was occupied primarily by students, which the investment memo says has a higher than average turnover rate. So citing to other properties is still not going to do it. What we can do is use an equivalent of a re ipsa loquitur argument to say, look, when you see something which is so out of whack, something must have went wrong. So when they say, we're going to increase the apartments from 3-bedroom apartments from 5 to 36, and they only increased 10 apartments at most, that's a specific allegation. When they say we're going to increase the 4-bedroom apartments from 3 to 14, but they create only between 2 and 4, that's a specific allegation in the complaint. These are specific things. They're doing the best they can with the information they have. If the court is asking the investors to say, well, you have to show what provide the information that was in effect beforehand, then no investors are ever going to be able to sue for fraud on this information because it's a black box. It's a non-public entity, it's a non-public information, and you'll never be able to get to that point. And the law is just not, first of all, the law is not that, and fairness can't allow for that result. Fairness cannot give bad actors a free rein to say whatever they want so that they could raise millions of dollars and with no consequence.
Thank you, counsel. Thank you.
Thank you, Court. Thank you, Your Honors.
Bonifacio?
Was he the other?
Good afternoon, Your Honors. I may it please the court, Stuart Gold for Appellant Yonatan Bonifacio. I'd like to make three quick points. The police commissioner imposed the harshest penalty upon appellant, which is dismissal from the police force with deprivation of his accrued pension benefits. And that penalty should be annulled for three different reasons. First, the facts of the case show that the penalty was excessive. The two memes at issue, they were inappropriate, and he should not have sent them, but there's no indication in the record that appellant had...
Would inappropriate be the fairest characterization of what was sent to the rest of the team?
Especially in light of his supervisory role.
Right, no, it was definitely offensive, but my point is that...
Racist, maybe?
I'm sorry?
Racist?
It was a racist meme, yes. My point is that, but the fact that appellant sent them, there's no indication that he indicated any approval of them or promoted them.
Well, did he say, for example, when he sent them, he could have added a disclaimer language saying, like, this is the stuff we're dealing with on the internet, I don't agree with it, something like that.
Right, so in this group chat, they shared everything. And there were two African Americans in the chat, and obviously he would not send a racist comment to his subordinates who are African American. What?
He did. I mean, that's what happened.
Right, but the point is...
No, and the point is there was no follow-up to it, right? There was nothing.
He didn't clarify anything. He didn't add a text once he was able to, because I understand he had his daughter in his hand, so he couldn't clarify what he meant by sending it. But later, he never clarified to say, this is unbelievable that this is out here in the public domain.
Right, but the fact is that this group, everyone shared everything, and everyone knew who the type of person appellant was. So...
Well, clearly not. Someone complained.
Right, but there's only one person that complained, and he made a complaint a month after the memes were sent, and at a time when this is Officer Seeley, and this officer made the complaint at a time when he thought appellant discriminated against him for something else, which ultimately was found to be unsubstantiated. So he only made this complaint about this meme.
But that doesn't change the offensive nature of the memes, the
Right,
lack of explanation as to why they're being sent to the team.
Right.
And this is at a time when, frankly, the city was on fire in some ways, right?
So 2 points. So I mean, even myself, I send offensive things to other people, stuff that I find offensive. That does not mean that I approve of the meme or promote it. I many times share stuff with friends.
Well, you're not a supervisor talking to your subordinates in a group chat with no context, right? So that doesn't matter.
Right, and so the ultimate issue is whether the harshest penalty imposed on appellant, being fired from the police force and losing all his pension benefits, was that appropriate? So maybe he should have lost. So maybe he should not have been promoted to sergeant, but he lost everything. He lost his livelihood, he lost his pension benefits. And when you compare this to other cases, for example, one of the cases in 2017, a police officer made a post on Facebook calling for the genocide of an entire ethnic and religious group and called for the destruction of all their houses of worship. And that officer retained his pension benefits. That officer kept his job, and the penalty that was imposed on that officer was merely forfeiture of vacation days. And under the First Department's case in Trotman versus Ward, the inconsistency of punishments imposed by the police commissioner renders a penalty shocking. The misconduct in my case was much less serious. I wouldn't even call it egregious, again, because the memes itself were offensive, but there's no indication that appellant had any hatred toward any other race. And he
Counsel, if I may, now, here the petitioner was aware right, that the commissioner maintained the absolute right to impose, various penalties when deemed appropriate, correct?
Right.
Okay. And that one of the penalties could be termination, correct?
Correct.
All right. So the specifications, which included conduct prejudicial to the good order, efficiency, or discipline of the department, and certainly petitioner pled guilty to the specifications, right?
Correct.
And that included what I just repeated about the conduct prejudicial to, et cetera, et cetera, et cetera. Correct?
Right.
All right. And so with that, the most severe penalty was termination.
Well,
No.
Oh, sorry.
Will you agree that that specification, the most severe penalty that could be imposed could be termination, which your client was aware of?
Well, you saying the most severe penalty that could be imposed by the commissioner, or that should be upheld by?
No, by the commissioner.
Right. The commissioner has discretion to impose anything, and if a police officer is discourteous to a civilian, police commissioner.
Well, but that's not what we have here. What we have here is, we know what, because he did not challenge the one of the memes, and we know that was, the murder of a, person of color by, a white police officer.
I'm sorry, was that a question?
I'm just saying.
Okay. Okay, and then I'd just like to also note that the respondents have made no argument about why appellant deserved to lose his pension benefits, and I think it's also telling that my adversary, did not feel that she had to show up in court to defend against the police commissioner's decision to terminate appellant.
Could be telling that the briefs were sufficient.
No, if you look at.
All right, thank you.
Okay, if you look at the parties' briefs, the respondents do not explain why forfeiture of his pension benefits was warranted, and they also do not distinguish this case where an officer made a Facebook post calling for the genocide of an ethnic group. Thank you, Your Honor.
No, I'm going to try to pronounce it again. You're the last people in the courtroom, so Malgarajo? Yeah, I'm sure it's not. I apologize for getting it wrong.
Good afternoon, Your Honors. May it please the Court, Teresa Frame from the MTA Law Department on behalf of the City of New York as well as the New York City Transit Authority. At the heart of this appeal is a statute of limitations issue. Petitioner did not file a timely notice of claim on the New York City Transit Authority.
That's a condition precedent, correct?
That's correct. And so then he was required to move for leave to file a late notice of claim.
Let me stop.
Well, did he ever file for a motion for late notice of claim?
No, Your Honor, he did not.
But did he have the opportunity to? Because as I understand the timeline, when he filed against the wrong party, the notice of claim, and that was in September of 2020, then in January 25th, the court directed him to file the notice of claim on transit. The court didn't direct him to make a motion for the late notice of claim. In essence, basically deciding that he was going to allow it.
Certainly, if the court had done that direction, then it would have been a little bit more misleading for the plaintiff. However, that was actually the city's attorney at the statutory hearing held by.
So the city's attorney filed the late notice of claim, went on to negotiate with him in terms of the defendant, the plaintiff's counsel granting transit 40 days extra to answer, and then turns around and says, wait a minute, we take that all back?
Your Honor, the Transit Authority is not required to alert the plaintiff that he hasn't filed a late notice of claim and then that he needs to seek leave.
Let me ask you this other question in terms of, because 50E does allow some discretion in the court's decision as to whether or not the plaintiff has served a notice of claim on the wrong party. It's not as if no notice of claim was served, right? And it's not as if there was this particular incident wouldn't have maybe placed the transit on notice. I mean, his hand was cut off. I mean, surely someone is aware of what happened. So I'm just wondering, why is this an abuse of discretion for the trial court to allow the case to proceed as it is?
If the plaintiff had moved for leave to file a late notice of claim, then perhaps some of those arguments that you articulated could have been persuasive. However, by the time the plaintiff realized that he needed to seek leave to serve a late notice of claim, the statute of limitations had already run.
Counsel, just to be clear, on January 25th, 2021, when he was told by the city that he filed, that he notified the wrong party, then he notified the correct party, right? But that was the city telling him that he filed against the wrong entity, not the court, because in fact the court here wasn't involved until April 12th, 2021. Isn't that right?
That's correct. So the city was really sort of doing a favor for a plaintiff, saying, "Hey, we're not the right people. Here's who you need to sue."
And what plaintiff did file that brings us here today, that was filed after the statute ran, correct?
That's correct, and that's what's really robbed the trial court of any discretion that they had to allow the plaintiff to.
What should we make of the stipulation about no motions?
Say again, please, Your Honor.
Stipulation. There was a stipulation extending the time for transit to come in, but no motions. How do we address that?
Well, that was a unilateral stipulation. It was executed only by plaintiff's counsel.
So it wasn't executed by you folks, correct?
Correct. So it's not a true stipulation in that regard.
Well, was there an agreement even though the stipulation wasn't executed?
I can't speak to that, Your Honor. I was not the one who was negotiating.
Counsel, what's your position that even if we find that there was an agreement, can an agreement do away with a condition precedent?
No, Your Honor, and that's because, and past that, even if you were to find that maybe transit was a little late in moving to dismiss the complaint, we're allowed to raise that at any point prior to trial, and we're well before that point here. Thank you.
If it may please the court, Matthew Simon of Matt Simon Law for the plaintiff.
So counsel, the statute 50E does require upon application, right? I mean, that's how it starts out, and there was no application to extend the time here. What do we do about that?
Well, Your Honor, I submit that it was timely. The original notice was timely upon the city. The city issued a claim number and acknowledged receipt of the claim.
But the city is the wrong defendant.
Well,
had the city done nothing, they could have moved for summary judgment and got the case dismissed, right?
Does notice on the city confer notice on transit? Is that your argument?
Well, that is one argument. And
how can that be? They're different entities.
Well, they acknowledged receipt and issued a claim number on other times when the notice of claim was.
The city did, but that's the wrong party.
I'm sorry.
The city did, but that's the wrong party, correct?
That's one of the defendants. The transit was specifically not noticed till later, and like justices pointed out, it was in line with after the plaintiff was produced for the 50H hearing, and I think what I'd really ask the court to look at is the case law where it explains that the city is not supposed to pull a surprise. It's not supposed to lull.
Well, wouldn't the surprise have been if they had allowed discovery going through and then they moved for summary judgment saying you got the wrong party here? They didn't do that.
They waited 2 years from the second notice of claim before, and they never actually technically moved. They went through, they filed an answer. There was a preliminary conference order. Discovery was exchanged. Demands were served on me. I served demands on them. I filed the motion.
Your position is that the city has some obligation to inform you that you filed against the wrong party?
Well, they have an obligation not to lull me into a full security thinking that the notice.
So estoppel. You're essentially arguing estoppel.
Yeah, yes, Your Honor. And there's case law, Bender and.
Well, Bender is a very different case, I think, right?
Well, it's one of the cases, but the point is if.
And the cases, I think even Bender says, it's really rare that estoppel is granted against a government agency, no?
I understand rare circumstances, but a quote would be, if the city wrongfully misled plaintiff to justifiably believe service of the notice of claim was of no consequence and lulled plaintiff into sleeping on his rights to his detriment, then the city should be equitably estopped from the failed.
But how did it do that here in this case? All it did was it proceeded with litigation like any other defendant.
It proceeded with a 50H hearing and then a second 50H hearing and acknowledged the notice of claim and never objected to anything. It continued through discovery, and it wasn't until my motion that in opposition and cross motion that this issue was raised 2 years later from the.
Counsel, what, if anything, did the transit authority do to, prevent, you from timely filing the notice of claim? Because that stipulation is just signed by one party. It's not signed by the transit authority. So what did they do? Any discussions? What did they do?
Well, the transit authority, when they were late filing an answer, I could have moved fault. We came to the agreement that I would allow them to answer with extra time.
I'm glad you said that agreement. Where is proof of that agreement? Because it's just a stipulation signed by one party, the plaintiff. So what was the agreement?
The other side sent me the stipulation, and they called me asking for additional time. I said, send over what you propose, and I'll send it back. That was sent over to me. I crossed out the motion. I signed it. I sent it back.
So the stipulation that was proposed was provided by transit?
Yes.
Did they ever send it back to you after you signed it?
They filed it. They filed their answer with it. That's what.
No, the stipulation.
The stipulation?
Yes, did they sign it and send it back to you after you signed it?
It was for them to file, not me. So they never sent it back to me. They filed.
Did they file it? They filed the stipulation?
I don't want to misstate. I believe they filed the stipulation with their answer, allowing them to file a late answer. Otherwise, it would have been rejected.
Thank you, counsel.
Thank you.
Turning to the equitable estoppel argument, that does not apply here because there's not any affirmative action that New York City Transit took to discourage the plaintiff from either.
I think we just heard a whole bunch of that.
Well, the stipulation, did transit file that stipulation with their answer?
I don't believe that Your Honor, that's not within the record, so I can't speak to that. However, I would say that the stipulation itself doesn't discourage plaintiff from doing anything. His argument.
Well, if you say it does in a sense, right? Because if a part of the agreement is that you're not going to file a motion to dismiss the complaint, if the plaintiff permits you to file a late answer and not go for a default judgment, then that is, in a sense, lulling them into thinking that everything is okay, right?
I would disagree, Your Honor. I think it has to be more directed towards the timeliness of the late notice.
Has the 90 days expired at the time the stipulation was filed?
I believe yes, Your Honor, it had.
Do you know the date of when the stipulation was filed?
Or, I'm sorry, not even filed, how just executed, even if it was executed by the plaintiff?
I do not have that in front of me, Your Honors, but I'm very happy to.
Is it in the record?
It is in, the stipulation is in the record. However, I'm not sure whether it is dated. Let me see. Yes, the stipulation is dated May 17th, 2021. And the time to serve a timely notice of claim, according to our own calculations, was December 28th, 2020. So that was about 5 months after the time had expired.
Anything else?
If there are no further questions, I will let you enjoy the rest of this lovely day. Thank you, Your Honors.
Thank you.
Maybe not for this long next time. Maybe not for this long next time.
Oh.